thing here for the YouTubers or whoever. Okay, we're here for our second case of the morning. It is David Walton, the appellant, versus Lake Sumter State College, case number 22-794. And again, it is Tuesday, February 7, 2023. You guys weren't here. Each side has 20 minutes. Mr. Levy, if you want, we have a standard 5-minute default time for rebuttal. If you want a different amount of time than that, just let me know, and I'll adjust the clock accordingly. You'll see the yellow light go off when you're in rebuttal. You obviously can continue to go forward at your discretion or stop at that point, but you get a cumulative amount of 20 minutes for both your initial and rebuttal argument.
I'll reserve 4 minutes.
You want 4? You timed it out pretty good, huh? So, and if there's any, if you either of you have any cell phones or electronic devices, just please put those in the silent mode or mute, and so he doesn't go off and distract counsel or the court. That being said, if you're ready, sir?
Yes, I am.
Go ahead, sir.
If it please the court, I am Toby Love of Egan, Love, and Sawicka in Orlando, and we're representing the appellant, David Walton. David Walton was a professor at Lake Sumter State College. Timeline is very brief. Hired in 2015, received a series of annual contracts, received a continuing contract in 2020, terminated in 2021. Our principal contention in this case is he could not be divested through a retroactive application of a new policy. He had a vested right that could not be divested by a new policy applied retroactively, and he was prejudiced by it. Had he been on notice of the new standard when he was hired, he and his supervisors could have done many different things to assure compliance with the standard. The standard was not in his continuing contract. He was not evaluated on it. He was made a professor under a continuing contract, regardless of the fact he wasn't complying with this new standard that was retroactively applied to his entire teaching performance beginning in 2015. Starting point in evaluating this case is his continuing contract. And the continuing contract has to be interpreted in light of Florida Rule 6A 14.0411. I'll refer to that just as the state rule, and some college rules that were enacted pursuant to the state rule.
Well, counsel, if I could just interject early on here. It seems to me there's two ways of looking at this case. One is the way you're advocating, which is my client had a contract, there's standards that he had to abide by, those standards were not made clear, sort of pulled the rug out from under him towards the end. Another way to look at the case is to say, well, a good cause for terminating a contract is that our department is no longer in existence. We no longer have an anthropology department. Was that, which of those issues was actually litigated here? Were they both litigated, or, because as I read the order, it seemed to suggest that the college terminated him because we don't have a program anymore.
Well, when you ask what were litigated, I would suppose both issues were litigated. What issues were considered was only the college's issues. The president's attorney presented a proposed recommended order that was adopted verbatim by the hearing officer and then adopted verbatim by the college. So,
well, let me actually, was there an announcement made, we hereby are going to dissolve the anthropology department?
No.
Effective a year from now, so that affected majors can, that are majoring in these courses? How did it play out factually?
All right, so addressing their best argument that they have the power to dissolve a department, first of all, they dissolved it based upon things that were relevant to his performance. So it was a performance factor. Under the state rule, they're supposed to consider performance factors when they evaluate him or when they terminate him, and they didn't. They had a new performance factor that they never promulgated.
Well, my question is, when is there the announcement we're no longer going to have an anthropology department?
Well, that was made when he was terminated. Matter of fact, it wasn't even made when he was terminated We found out while the hearing was going on and the president testified that, oh, by the way, he's not going to be replaced. We're not instructing in anthropology anymore.
So is there evidence in the record, other than the termination slip that he got, that the institution was going to eliminate anthropology in the department?
No prior notice prior to his termination. No rule in place with standards on how to terminate a particular discipline. No board action, and they could take board action to discontinue a discipline after consultation with the faculty. There was no prior board action. There was simply an action by the president with no rules in place that would notify Walton that his position could be abruptly terminated because of lack of student interest. There are college rules based upon the state rule on how and why you can discontinue a position, and the state rule and the college rule only speak to reductions in force, in which case the same criteria to appoint a teacher to a continuing contract have to be applied in determining which ones to let go. So you're supposed to look at a list of criteria and compare each candidate to the other candidates, none of which was done. So this was a abrupt termination without a rule in place. Maybe they could have enacted a rule that said henceforth, prospectively, any discipline that doesn't have an enrollment of so-and-so number of students may be terminated, and they could have had a board action preceding his termination stating, why shouldn't we terminate your discipline? You're only getting X number of students in your classes. So none of that happened. All of this was done in the context of terminating him with no prior notice. And it was done contrary to the prior practice of the prior vice president and a course of dealings that went on for 6 years where this was not a basis for termination or eliminating a discipline.
So his notice, the notice that he received from the president didn't say, we're terminating you for cause because we're discontinuing the anthropology classes here at the school, and therefore we obviously don't need an anthropology teacher anymore.
The notice itself said you're terminated pursuant to the state rule and this college procedural rule, and then he was supplied a 2-page memo from the vice president that said, I've looked at all the teaching loads of all the faculty members, and David Walton had to rely on these SOS classes more often than any other teacher. Some of them were doing it maybe once a year or once every 2 years. He was doing it more consistently. I recommend we terminate him. So that was after he was notified of his termination. He was given that reason. And in the course of the hearing, we learned that we're not going to replace him. We don't want anthropology anymore.
So that's what you're saying. That's when your side, Mr. Walton's first aware of, oh, by the way, we're just not going to have anthropology. I mean, you would concede that if the school properly terminated the anthropology classes, that it would logically make sense that upon proper notice that they could terminate his position because they don't need his services.
I think so. The problem here is he was fully qualified to teach all the classes he taught, and he taught a full teaching load, and the continuing contract did not say he was not teaching a full teaching load, and suddenly they reverse course from over 6 years and say, we want somebody who's a professor in anthropology to teach all anthropology. Now, if they did that, enacted that rule and applied it prospectively, I would not have a legal issue with it. It's within their power to do. I have an issue with them changing policy, not enacting the change in policy prospectively and giving him a chance to perform instead of retroactively applying a new policy to what he'd been doing since 2015. And he could have shown that he could have put more anthropology classes on board. He could have taught additional classes. He could have taught so-called B classes that commence 7 weeks into the semester. So this was not just a surprise to him, but to the people who supervise him, the dean. It would have been a surprise to the former vice president of academic affairs. So we are not trying to tell the college not to terminate somebody if there's low enrollment, or how to present classes that are attractive to students. We're just saying, put people on notice of that first before you hire them, before you give them continuing contracts, and if you enact the policy, apply it prospectively, and put the policy in the continuing contract so the teacher is on notice. Maybe he wouldn't even want to take the job. So jumping ahead to the 3 state rules, there's 1 state rule. There's 3 ways of terminating somebody. One is nonconformance with post-award performance criteria, and those criteria are set out in the state rule itself. They're the same criteria used to hire a professor, and they've got to be used for the periodic reviews, which were done on Professor Walton every year, and he got superlative reviews with no mention of his not teaching sufficient number of anthropology classes. So we're saying that, in essence, they came up with a new unpublished post-award performance criteria that they should have enacted previously and evaluated them on and placed in its continuing contract. There's a state rule on reduction. The program was not reduced. The program was general education, and that was not reduced. They just eliminated his discipline. And when you terminate via a reduction, you're supposed to select who to terminate and compare Walton to others, again using the same criteria in Section 3 of the state rule. There are college rules on reductions that were not followed. You're supposed to declare a reduction in force based upon a need to reduce expenses and terminate annual and part-time faculty first. And there was no new rule put in place that said, well, we need to change course. If we hire somebody to be anthro, he needs to teach 5 classes in anthro or 5 classes in poli-sci or whatever. So no opportunity to comply with the rule in this retroactive application to whatever he'd done since 2015. They're claiming they had cause. So there's this generic category of cause in the state rule. However, in certain circumstances, cause can be vague as applied to an instructor. There's no state rule expressing what the cause was. There's no conduct on Walton's part that was so obviously wrong you wouldn't need a rule, and he was not evaluated on this criteria, and he was not criticized or disciplined on this criteria prior to his termination. So in the context of Professor Walton, it was a vague criteria as applied to him. Also, cause cannot be arbitrary. That violates due process. And here, you cannot retroactively apply a new standard to divest an instructor of a vested right. He first must be afforded notice and opportunity to comply, and the new policy must not be applied prospectively to everything he'd done since 2015. The college could have adopted a rule. It did not. And this goes into our rulemaking argument, which is a hard area for me to understand, but Statute 120.52(8)A does talk about enacting rules and not just acting on unpublished rules. It also addresses vague standards that vest unbridled discretion in the president, and we think that both of those prongs apply. The college could have and should have enacted a rule that says we expect professors to teach at least X number of classes each semester in their field. They did not. They reversed a policy, which they're privileged to do. They're not bound by their predecessor's policy. They just have to reverse it, announce the reversal, and apply the reversed policy prospectively.
In this case, couldn't the college have said, next year we're going to phase out anthropology courses. We understand you're on a continuing contract. At our discretion, we're going to give you a 1-year annual contract, teach the courses for 1 more year and some of these student success courses, and life goes on.
Now, they probably could have done that, and maybe this is not in the record, but I see UFF contracts where somebody can serve out 1 year after he's notified. So that could have happened. They
Here,
could
the
have.
letter came in at the end of the semester, I assume. It looks like
Right.
it's June 3rd, so everything's done for the term, and
And he had almost an impossible time to line up any employment in the fall. Those positions were taken. So again, they could have enacted a new standard, made it clear they're applying it to everybody, what the standard was, and he would have had notice. And when they enacted the new standard, there could have been public comment. Public comment could have been if somebody's been here on a continuing contract, give them some time to comply after you're announcing a new policy. Who knows what a new rule may have looked like, but yes, they could have enacted one so long as it was with prospective effect.
could you clarify, is anthropology a major, or are there just courses in anthropology that can be used to satisfy?
I understand it as a course that can be used to satisfy. I'm not aware that it's a major. Well, so we're asking the court to reverse and remand with instructions to reinstate Professor Walton and provide him back pay. If there are no further questions, I'll save my time for rebuttal.
Very well. Thank you, counsel.
May it please the court, my name is Brian Koji. I'm here on behalf of the Lake Sumter State College. The central issue in this case is, does the college have the ability to terminate their one and only anthropology instructor when it makes the decision, which it has complete discretion to do, to cease offering anthropology courses? And does the college have to provide notice a year in advance when it's going to terminate the anthropology professor because it ceased to offer anthropology courses? The context here is very important. We are here, obviously, in challenge to the final decision of the Board of Trustees of Lake Sumter State College. The facts have been heard. There was a full-blown evidentiary hearing lasting a full day, 6-7 witnesses, 46 exhibits. Lots of these exhibits were emails through the course of the entire employment tenure of Dr. Walton. Emails constantly advising him that you need to generate interest in anthropology courses. He was and has been the only anthropology professor in the history of Lake Sumter State College. The brief
Did the
sets
email
out.
ever say your 15 hours have to be entirely in anthropology?
It was never explicit in that regard.
No email, not in the contract. Was he ever told in any way that you can't do these SLS classes to bring your load up to 15?
The hearing officer found that the expectation was he explicitly in a black and white language? No, but piecing together all the emails, the contract, the job description, all of those things, the factual finding of the hearing officer was the expectation of both Dr. Walton and the college was that he would satisfy his load teaching anthropology. In fact, some of the emails authored by Dr. Walton himself indicate that he does not want to teach these SLS courses, these student life skills. It's the course you take as a freshman in college, that the college does not employ any full-time contract teacher to teach those courses as part of their load. Those are typically done by your adjuncts. They have, as the hearing officer found, they have occasionally allowed somebody to make out their minimum 15-hour load using some of those. But Dr. Walton was the only one throughout the course of his tenure that had to do that almost every single semester. In fact, all but one semester.
He was always allowed to do so and never told you won't be allowed to anymore.
Not in those terms, but again, the factual finding of the hearing officer is the expectation. That was the expectation of both parties. In our view, the appellant is trying to relitigate that factual issue.
Well, point us to the record where Dr. Walton said that. It is my expectation that I cannot continue teaching this level of SLS courses or I'll be fired.
There's an email in the record where he says, my preference is not to teach any more SLS courses. Now, he does say in that email chain that if I have to do it, I have to do it.
I disconnect. I don't understand how those two address the question I just asked.
Well, maybe I
He said
misunderstood,
he
Your
didn't
Honor.
want to teach him, but that doesn't mean he's going to be fired because he's,
No, I'm not suggesting that he was told you're going to be fired if you can't teach 5 anthropology courses up until the time when he was. What I'm saying is the expectation of the college and of himself was that he had to make out his minimum load teaching these courses. It's not just the emails, it's the contract itself, which lists him as the anthropology instructor.
but my question was, where's the evidence that he himself, the doctor, said, I understand that if I don't stop teaching these SLS courses, I'm going to be fired?
No, there's not that explicit evidence in the record, Your Honor.
Okay,
And
so, it's
I-
not,
if I-
so it wasn't his expectation that he'd be fired if he was teaching these.
It was his expectation.
It was aspirational. Yes, we'd like to have all professors do as few of these as possible, the tenure, the continuing contract for folks.
Well, to me, Your Honor, that's a factual issue. What was his expectation? Hearing officer found his expectation was he would make minimum load teaching these courses. Hearing officer did not say, and now be fired if I don't. If that's the point you're making, I agree with that. But the expectation was when he was hired and throughout his tenure, he would have to make minimum load teaching anthropology. Now, this was a new course offering in 2015. The regulations changed that allowed this course to be used as part of the core courses.
How many other professors on continuing contracts taught SLS courses?
The record evidence is that you had a handful, 3 or 4, that occasionally did it, but none, not a single one, needed to use it on a regular basis to make out their minimum load. It's the exception, not the
So
rule.
just, you're saying a handful, there's only at most
5 or 6, I think, is the term. It's in the record, it's factual finding as part of the hearing officer that all of those were distinguishable, and not a single one of them had to use it to make out their minimum load on a regular basis. So what occurs here is, in the same, it's not in a vacuum again, we have declining enrollment up to 10% at the time this decision is made. Now, to some of the questions earlier did the college put him on notice that they were going to cancel the anthropology courses? No, that didn't happen a year in advance. It did happen the summer in advance, and that's the normal practice of the college. The District Board of Trustees has the unfettered discretion to cease offering courses. They admit that in their black and white, in their brief. And that's what happened. At the end of every year, we look at the enrollment numbers. There's hearing officers' findings of fact that every year they look at the scheduling. They try and get interest, and then the schedule is constantly in flux, those 2 or 3 months before the semester starts. And this is all in the record. At the end of the school year, the 2020 to 2021 school year, academic VP, Vice President of Academic Affairs, does a study of all of these things. We have these declining student numbers, declining revenue. What are the conclusions to draw? And he looked at these things. There was no preset idea to go in and target Dr. Walton or even anthropology. It was just a simple study of the schedule. And he concluded, based upon the analysis, that Dr. Walton and the anthropology courses are the only ones who cannot make their load teaching in their discipline. He's the only one, he's only ever been the only instructor that's taught these courses. So the recommendation was made to cease offering these courses. The president makes that to the Board of Trustees, and they agree with it.
And that was made before he was given notice of termination?
No, he was given notice of termination in conjunction. It was a simultaneous. It was happening in June of 2021. So once that recommendation is made, he is being advised by the president that I'm recommending your employment be terminated because we're doing away with these courses. They then hold a kind of pre-disciplinary conference where they talk to him about it. He's out of state because it's summer, but they do a remote conference. And he's given at that time the council reference the 2-page memorandum, which is Dr. Vitality, VP of Academic Affairs, going through the analysis of how he reached a conclusion to recommend doing away with anthropology.
The first letter he got from the president didn't say, I'm going to recommend that your contract not be renewed, did it? It said your contract's not being renewed.
Correct. It's saying
That was before any decision was made from the board to discontinue the program or the position.
correct. It's not as artfully drawn. I'm certainly, in fact, he had to go to the board and he had to go through the process. The idea from the president, this was what the president testified during the hearing, that he wanted to sit down with him and talk to him and go through all of this stuff, and was going to go through it. Once he was notified of that and invited to come have that meeting, it became aware that he's out of state. So they had that meeting, went ahead and sent him all the paperwork, the recommendation, and then had the meeting, had a full discussion. Findings of fact by the hearing officers goes through all of this. Full discussion of the reasons and why we're doing what we're doing. And he's notified at that time that he can challenge it. He can file a petition and go to the board, and the board would appoint a hearing officer, which is exactly what happened. He had full-blown discovery. There were depositions taken all within a month and a half, and then full-blown evidentiary hearings held where he could contest and raised all these arguments, except for the rulemaking, the unadopted rule argument. They raised all of these arguments about not giving notice and changing rules. There was no changing rules, no changing policy. The cause is we don't have an anthropology course anymore. Do we have to have a rule that specifically says, lays out and delineates that if we do away with the only course that you're hired to teach, that constitutes cause? Our view is no, you don't have to have that level of specificity.
What do you base it on? You have a view, what do you base it on?
Well, the case law I'm citing, I think the most analogous cases that we've cited in our brief, the Jacker case is one of the cases, and that's...
So there's no rule or statute you're relying on?
Yes, I'm sorry, Your Honor, I misunderstood.
I like to go to the rules or statutes if they're...
Yes, yes.
That's that first DCA stuff.
Apologies. The rule, the State Board of Education rule that we're relying on is the rule cited by the appellant, the 6A-140411, specifically subsection 7. That one lays out 2 of the 3 reasons you can terminate somebody on continuing contract. One is for the performance, and there's a whole post-award performance criteria that Dr. Walton's counsel covered. And the other is, it says, or for cause. And that's what we're relying on. The the Board of Trustees then has a rule, the Administrative Procedure 5-15, which essentially reiterates that same rule. It does not go into detail and say, well, here's what cause is every single instance where you could ever have cause. If that's their argument, that's the premise we are rejecting, that you have to have a specific delineation of every cause known to man. The case law does not support that. We are not saying we're terminating him for performance issues. The post-award performance criteria, in our view, is kind of the red herring.
Let's get away from the 15-hour load. Let's say that Professor Walton had, every semester had done 15 hours of anthropology teaching. So that leg is out on this case. So now we're down to the school. This is my hypothetical. I know the facts are different. The school decides, after consultation amongst itself, that we don't want to have an anthropology class. We have no basis to keep the anthropology class going because we're getting 2 students a semester signing up, and it's just not feasible to do this anymore. It seems that your opponent's argument is, if that's what you want to do, you certainly have the prerogative at some point to do that. You can't just send me a letter saying, we are terminating you for cause, and then during the course of the lead up to the evidentiary hearing, he finds out, well, we're just getting rid of the anthropology classes, that's why you're being terminated. Mr. Lev is saying, if I'm understanding him, is that you have to do a little bit more, there has to be some kind of notice or process to do that, not just one day. And I'm not saying your president just woke up one day and said, no more anthropology. And that's problematic to how, in terminating a tenured professor. That seems to be his argument on part 2 here. How is he incorrect?
Well, Your Honor, it's incorrect in the sense that Florida statutes provide that the Board of Trustees has the unfettered discretion to decide what courses they want to offer. If that's their argument, is we could not have discontinued the anthropology course.
I don't think he's saying that. I think he's saying there has to be a process. In other words, he couldn't be walking into the first day of anthropology class in this fall semester, and the president says, not for nothing, come over here, here's a letter, the program's over, I'm dismissing these kids, and your job is ended.
Absolutely, there is a process. The process spelled out in the college process is we give you notice, we get to meet with you before the semester happens. If you want to challenge that, you can challenge it, you file a petition, and we have a full-blown hearing over it. Same thing, same process. We want the Board of Trustees wants to do anything. Their process is they have to put it on the agenda, has to be recommended by the president, put on the agenda. We're not going to offer anthropology at a public meeting. They have to vote on it.
I mean, I think
And
at the
that's
end.
happened. All of that happened.
Excuse me, if I'm at the end of the day, I think I don't think Mr. Leb disagrees with his client, Mr. Walton, could be released or his contract could be terminated if, in fact, there was never going to be any more anthropology classes, or at least in the foreseeable future. But how you went about doing it violated his rights under his contract, and your position seemed to be, no, we're entitled to do this. We all agree we can do this, and we did it in the appropriate manner under the statutes and the rules.
Correct. All of which is embodied in his contract. His contract is subject to all of these rules. These are things that happen every year that the college, pursuant to its rules, decides what course to offer. His view then is I have to be given some special notice that's nowhere in the statute, nowhere in his contract, nowhere in any procedure that I need to be notified a year in advance if you might discontinue my course offerings. There is no legal basis for that argument. There is a process for doing all of this, and the process was followed.
So following that through, so even if we think that there was some error in the process of, oh, by the way, he never was really told he had to teach 15 hours in anthropology, because there's no competent substantial evidence supports that he was under the impression that if he didn't do that, he could be terminated. Setting that aside, right or wrong, it's still right on part 2. We terminated anthropology classes, therefore that it gives us good cause to terminate our only anthropology professor, and we gave you the right to argue against that, and everybody heard, the evidence was presented from both sides, due process was provided, and it turned out adverse to you, Mr. Walton, and it should turn out for you adversely here today. Is that a summary of where we are?
Your Honor, that is definitely our position. We understand Dr. Walton is a sympathetic figure here. It's not a performance issue, not a misconduct issue. Whether he had the expectation or not at the time he was hired or whatnot, even though we think he did based on the factual findings, ultimately the Board of Trustees has the ability to discontinue anthropology courses. Once that decision's been made, it's cause for us to let go, regardless of his expectations, our one and only anthropology teacher, and there's never been anthropology since then. It's not as if we did it with some subterfuge. There's nothing in the record about that. There's no argument about that. It's just a matter of fact that anthropology, unfortunately, cannibalizes, or I should flip it, the government courses and the history courses cannibalize the student interest in the anthropology courses. Once that became aware, the Board of Trustees stopped offering anthropologies. Of course, we have to continue offering because it's a core course and it also is required civics courses, the American government, and the history courses. That's what's happened here, and that's all the Board of Trustees did.
Let me ask you a question about
Sure.
the contract again. Your argument is that Dr. Walton was terminated for cause, which typically implies misfeasance, malfeasance, something like that. But this has nothing to do with his performance. The cause that the board is, or the college is relying on is discontinuance of this position. I think it's section 6 of your brief, page 44, you talk about this, that the contract authorizes termination if the position has been discontinued. The way I'm looking at the contract, he can be terminated for cause or as an alternate if the position is discontinued. They're not the same thing. The way it's worded is he can be suspended or removed for cause. The contract may also be terminated by the board for discontinuance of the position. Can't that be read to say discontinuance of the position is not cause? It's not for cause? It's set out as an alternate. So you can do it for cause, or you can do it if the position is discontinued. You're saying they're one and the same. That's not what his contract says, at least not the way I read it.
Well, respectfully, I think it is subsumed within the cause. The cause is the catch-all, if you will. Yes, there is other language, and there is a
That's not what the
separate policy on.
contract says. Maybe that's what the rules say, or the statute says, but that's not what his contract says. It says he can be terminated for cause. As an alternate to cause, he can be terminated if the position is discontinued. It doesn't say including discontinuance of the position. It says an alternate way to get rid of him would be to discontinue the position. So it would not be cause.
Well, again, what the evidence at the hearing was, and I think there's an overlap there, respectfully, but what the evidence of the hearing is the college didn't handle this as a reduction in force. This issue came up, is it a reduction in force, because there's a separate procedure for that. It didn't because this is a course offering, it's not a discipline, it's within a larger subset of the college there, the arts and sciences, and it only affected one course offering, which happened to affect one person. Did not view it as a reduction in force. Could we have went back and viewed it under those lens and followed that procedure? The procedure is largely the same. Ultimately, you end up in the same boat where you get a hearing. Yes, we could have done that. To the extent that the contract speaks to both of that, our position is the cause it's not mutually exclusive, Your Honor. The cause is the catch-all, if you will, because as the cases cited in our brief suggest, you cannot have a comprehensive definition
Same
listing
if it was a catch-all, it would say you can be terminated for cause which would include or could include discontinuance of the position. Contract could have been worded that way, but it wasn't. And again, it's the college's contract.
It's a form contract given to all of the continuing contract instructors, so.
Well, it wasn't
again,
drafted by Dr. Walton, that's my point.
It wasn't, but the hearing officer's finding of fact do recognize a form contract. So, again, I think we have to look at the circumstances, not only the language of the contract, in the context of the rule, the state rule, 14.0411, the administrative procedure at the college, 5-15, and the facts here.
And part of the rule suggests that, and I'm looking at subsection 7B, that a full-time faculty under a continuing contract can be terminated, quote, upon consolidation, reduction, or elimination of an institution's program, which seems to me to suggest that if you wanted to discontinue a program, fine. Thereafter, you can terminate someone, but not necessarily the other way around, which is you can't terminate them because you want to discontinue the program.
Yeah, and this kind of goes to what, I'm sorry, may I continue? I see my time.
Yes, go ahead.
Just goes to what I was referencing earlier. The college did not handle this as a reduction in force or program. It is not a program. Anthropology is not a program at the college. It's a discipline, a course offering within a larger discipline. So we did not go under that procedure. Ultimately, they end up in the same boat where you end up with a hearing before the Board of Trustees and factual findings, and they make a conclusion. I don't know that the result would have been different, but that's not the way it was handled. Thank you, Your Honor.
All right. Thank you, counsel. All right, counsel, you have 4 minutes, 40 seconds in rebuttal.
All right, I'll cover 3 or 4 topics. First of all, I think Dr. Walton's latest expectations upon hire are irrelevant. Also, the finding made by the college wasn't based upon substantial competent evidence because Dr. Sador was not employed there and involved in hiring him, and what they found was contrary to what Dr. Walton testified. And above all, I think there's a pro-evidence problem here. Whatever anybody's expectation was in 2015 needed to be set forth in the continuing contract, and it wasn't. Nothing in the continuing contract told him he had to teach 15 credit hours in anthropology, and nobody up to the Vice President of Academic Affairs told him that was policy. So the most important things, the contract itself and the course of conduct after he was hired. You can't figure out and make fact findings on what may have happened back in 2015 if he had known it was policy. It's all speculation. He said he would have brought more classes on board a lot sooner. He could have gotten B classes. The supervisors might have been less intent on putting him in SLS classes. None of that is anything you can make a finding on.
Let's set aside the SLS class for a minute. If the email from the president to your client simply said, sorry, you've done it, you've been a great professor, but we are no longer going to offer anthropology courses here at the college because there's just little student interest in signing up for these, and we've decided to discontinue anthropology classes. Therefore, we are discontinuing we are terminating your contract because you're an anthropology professor. So, good luck, and we wish you well. and that's in fact what happened, they terminated the class, why is that not? You have a hearing, and you can contest whether that's in fact factually accurate, and assuming it's factually accurate, the hearing officer found that, why doesn't that?
Because he's not on an annual contract, and he's not at will, and he can't be employed or discontinued for any reason. The reason has to be made known to him before the termination occurs. Here, there was no warning. What's wrong with teaching, as he did, 4 classes of anthropology in the semester? Nobody told him that was wrong. Nobody evaluated him and said that was a policy. You cannot abruptly change the policy, which had been...
I mean, let's say he was teaching anthropology all the way through. He wasn't teaching any of these SLS classes, and then he had 5 students per class, and at some point, the new vice president came in and said, this is just not economically feasible. We're not generating the interest. We are going to, I recommend to the president to terminate this program, or this class, forget about the program, this class, which the president does, and then he sends the email to your client.
Oh, that would be fine if they had enacted a rule, if that rule was included in his continuing contract, or he had been put on notice of it. The Board of Trustees never put on notice of it, never issued a rule. It was a surprise to the supervisors, the deans. It was a brand-new policy that reversed a prior policy.
Policy being that if you don't have enough students, we have to put something in the contract that says, oh, by the way, if your class is not generating enough interest, we're going to be done with the class at the college, and then therefore your contract will end?
I think that's fine if he was an annual contract where they could non-renew him for any reason.
Not even on a continuing contract? You're saying,
No, I think if you have a continuing contract, you should be put on prior notice of what the board's policies are. They did not have a policy setting standards on how many classes you had to teach.
it's not how many forget that. Let's say that he taught anthropology all the way through, so they're not going on you didn't teach your load. They're just saying the load you're teaching, there's 3 students in each class, and we've decided not to have anthropology classes anymore. Therefore, we're terminating anthropology classes at the school, and you're our only anthropology professor, so...
That needed to be a board policy setting a standard on how many students he was expected to have in his class every semester. There was no such board policy putting him or his supervisors on notice. You cannot discontinue a continuing contract teacher absent a policy. They had a policy on how to discontinue a program or a discipline within a program in the case of a RIF. They did not have any policies putting him on notice that his job could be discontinued and the course discontinued based upon low enrollment. Maybe they could have, maybe they can in the future. They cannot enact it and prospectively apply it, and after he's been going in a different direction for 6 years with the permission of the Vice President of Academic Affairs. So I don't have a problem with changing policy. You just have to put them on notice and apply it prospectively.
Okay. All right, counsel, thank you. Your time's expired.